Hi, I'm Darcel Lobo. I own Dow Law Firm, and today we're going to talk about transfer on death deeds. Now, we've talked about transfer on death deeds before, but it comes up a lot, and there can be a lot of questions about them as far as how they work when it comes to transferring real estate or doing one in conjunction with your estate plan. And we're talking about them as it pertains to Washington state residents. I am an attorney, but I'm only licensed in Washington state. Not all states have transfer on death deeds, but if you're in a state that has that as an option, but if it's not Washington state, you'll want to speak with an attorney licensed in your state. So this is for Washington state only. So a transfer on death deed, what it essentially does is that it allows you to name someone as a beneficiary to a piece of real estate. So it could be your home, it could be a vacant lot, it could be a commercial property where you are naming someone who will receive that home upon your passing. If you do this with the transfer on death deed with that beneficiary named upon your passing, that property will just go to who you have named. Now, whoever you've named is going to have to file what's called a real estate excise tax affidavit and a death certificate with the county recorder's office to prove that you did in fact pass away and for that transfer to happen. But there's no probate to go through, there's no new deed needed. It will go directly to who you have named. And let's say you're a married couple and there's two of you on title currently. So the property would pass pursuant to the transfer on death deed upon both of you to pass, right? So if it's a married couple, upon the two spouses passing, then it would go to who's named as beneficiary in the transfer on death deed. So if I have a married couple on title, if they've done a transfer on death deed, and let's say just one spouse passes, the surviving spouse remains the sole owner of that property. Then upon the second spouse to pass, then it would go to whoever they have named on the transfer on death deed. Now the transfer on death deed, we prepare it now and it gets recorded now with the county. You need to do that during your lifetime. A transfer on death deed cannot be prepared after you've passed. You have to be able to name that person as the beneficiary. And if you have more than one person that you want to inherit the property, that's fine. We can list more than one person on the transfer on death deed. So let's say you have two children or three children and you want them to co-own the property equally upon your passing, we can do so in that transfer on death deed. So a few caveats about using the transfer on death deed, because yes, it does simplify and streamline the process, but there's a few things to keep in mind if you're doing that. If the person you want to leave the property to is a minor, we're going to want to look at a different option, whether it's a will or a trust. Because we're especially going to need to control the inheritance for a minor, and so we need to have some more parameters in place to protect the inheritance for a minor. So if you have a minor that you want to leave it to, transfer on death deed may not, be the best option. We're probably looking at a will or a trust or, your estate plan to provide for that minor. If you want to have any kind of restrictions on that person's inheritance of that real property, the transfer on death deed may not be the best option. Again, you may want to look at a will or a trust. If the person you're leaving the property may have some financial issues or concerns, they may have creditors out there, maybe some liens against them or some past due taxes or other debts, we might want to talk about this before you do a transfer on death deed, because those items can and probably will attach to the real estate once it gets transferred to that person's name. And keep in mind, if we do the transfer on death deed, it gets prepared and recorded now, so anyone could see, it's public record, that that person you've named is going to receive that property. That could be good, that maybe it could not be so good in certain scenarios. So a transfer on death deed is a useful tool, not always the right tool for everyone. And if you have a revocable living trust as your estate plan, that trust is going to control distribution. Your trust is already going to avoid probate. So you may not need a transfer on death deed. You probably don't need one if you have a revocable living trust, because that's already, again, going to avoid probate for your estate. So there can be pros and cons and times when it is the right option or maybe not the right option. So if you have questions about a transfer on death deed, you want to look into having one prepared, you want to find out if it's right for you, you need help with your estate plan, you're not sure what you need, what you don't need, feel free to reach out and we're happy to see if we can help. Our number is 206-408-8158, or you can visit us online at dowlawfirm.com, and I'll have both of those linked down below for you. All right, have a good day, and I'll see you in the next video. Thank you.